Good morning, everyone. This is the meeting of the Joint Standing Committee on the Judiciary, and we're happy to have you here today to do two public hearings. We have a quorum of committee members, and we're going to start with introductions. Representative Hagan, I know you need to go to other duties. Can you quickly introduce yourself, please?
I can. I'm Dave Hagan. I represent House District 101, Hamden and Newburgh, and I'm teaching World War II to 8th graders today. Should be fun. They're having a test, Mr. Babbage.
Thank you so much, Representative Hagan. Next we'll move to Representative Newell for introductions.
Thank you, Madam Chair. Good morning, everyone. I'm Rena Newell. I am the Passamaquoddy Tribal Representative.
Thank you. And Senator Sanborn?
Good morning, Senator Carney. My name is Heather Sanborn. I represent Senate District 28, which has a lot of road construction going on this morning. It is part of Portland and part of Westbrook, so I apologize for being tardy. I was stuck in traffic.
Glad you made it. Representative Evangelos?
Morning, everyone. Jeffrey Evangelos, House District 91. I reside in Friendship.
Thank you, Representative. Representative Babbage?
Yes, good morning. My name is Christopher Babbage. I represent House District 8, which is the town of Kennebunk. And there's no substitute for preparation, but I do wish Representative Hagan's students good luck this morning.
Thank you, Representative Babbage. Representative Sheehan?
Thanks, Madam Chair, and good morning, everyone. My name is Erin Sheehan, and I represent Biddeford's House District 12.
Thank you. Representative Harnett?
Thank you, Madam Chair. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner, where I reside.
Thank you. I'm Ann Carney. I represent Senate District 29, which includes Cape Elizabeth, South Portland, and some of Scarborough. And this is going to sound really ridiculous, but Representative Newell, did I already call on you? I've been multitasking. Thank you.
Yes, thank you, Madam Chair. I wasn't forgotten today. Thank you.
I know. I'm sorry. I'm doing too many different things all at the same time. And we're joined by our committee analyst, Peggy Reinsch, and our committee clerk, Susan Panett. They'll be with us this morning. And it's nice to see everyone. So we have work sessions on two bills. We're going to start with LD 1688, an act to improve consistency within the Maine Human Rights Act. And then our second bill is LD 1692. We'll take them in that order. And that's it for today, so I won't post the order in the chat. And here to introduce LD 1688 is our colleague, Senator Hickman, and I will bring him over from the attendee part of the meeting. Ms. Padette, could you please bring Senator Hickman over if you don't mind? Thank you. Welcome, Senator Hickman, to the Joint Standing Committee on the Judiciary. We're happy to see you today.
Thank you. I'm very happy to see you as well. Good morning, Senator Carney, Representative Harnett, and distinguished colleagues of the Joint Standing Committee on Judiciary. My name is Craig Hickman. I represent Senate District 14, 11 towns in Southern Kennebec County in the Maine Senate. I Zoom before you today on behalf of the Maine Human Rights Commission to present LD 1688, an act to improve consistency within the Maine Human Rights Act. As the Senate Chair of Labor and Housing, as the first openly gay African-American to serve in both chambers of the legislature, as a former cross-gendered performance artist and substitute teacher, and as the owner of a public accommodation, I am the Maine Human Rights Act personified. I would therefore like to thank Senator Carney and Director Sneerson especially for allowing me to present this bill, my first and only bill of this session, given my late arrival to the 130th legislature. I have always said that I would be a strong voice for those who cry in the dark, and the Maine Human Rights Act exists precisely to protect the people behind those voices. This bill today addresses inconsistencies in the protections provided in the different areas of jurisdiction under the Maine Human Rights Act. The summary says, including adult family members dependent for care in the definition of familial status, including familial status as a protected class in employment, including age as a protected class in public accommodations, and clarifying the scope of the Maine Human Rights Act application in education. The bill also clarifies that sexual orientation provisions in the Maine Human Rights Act extend to gender identity. We need to get the language right so that the laws mean what it says and does what it means. Given the political discourse of late, especially regarding some of the legislation this committee has previously heard, extending protections to gender identity is crucial. As a former cross-gender performance artist who toured the country to present, among other things, my literary performance piece entitled Portraits of a Black Queen, and who was featured in 2 books authored by the great Leslie Feinberg, one entitled Transgender Warriors, Making History from Joan of Arc to RuPaul and Dennis Rodman, the other entitled Trans Liberation, Beyond Pink or Blue. It is about time that the law is clear that trans people must not be discriminated against in employment, housing, education, or public accommodations. Back in 1993, when I was young and some say pretty, and a paragon of androgyny, the cover photo of my book, Rituals, Poetry, and Prose, caught the eye. Leslie Feinberg featured that photo in her book, Transgender Warriors, which I mentioned earlier, with the following quote. I'm a Black gay performance artist. This was back in 1996, so just so you know. Man enough to let his woman shine, and woman enough to let his man roar. I find that as a cross-gendered artist and person that I have a very big responsibility to myself and to the people who read or hear my work, because gender roles stifle, and in my opinion, are the basis for all oppression. I feel like the world would be liberated if people just ignored all of that. I am often seen by people as a, what's that? To which I usually respond, isn't beautiful enough? And faces fall and crack and eyebrows may raise and people are left thinking about something that they didn't expect to be thinking about because I wouldn't keep my mouth shut. And so I suppose when I go out into the world, I carry it all with me. And my very presence is for most people a confrontation. I will close with a quote from James Baldwin, my favorite American writer, which is featured in book 4 of my award-winning memoir, Fumbling Toward Divinity, The Adoption Scriptures. James Baldwin's quote goes like this: identity would seem to be the garment with which one covers the nakedness of the self, in which case it is best that the garment be loose, a little like the robes of the desert, through which one's nakedness can always be felt and sometimes discerned. This trust in one's nakedness is all that gives one the power to change one's robes. And with that, I will finish up and take any questions you may have. Thank you for the opportunity again to present this bill.
Thank you so much, Senator Hickman. Committee members, are there any questions for the bill sponsor? I am not seeing any. I just wanted to note that I know that you were elected in March and didn't really have a chance to meet the bill filing deadlines. And if you had one bill this session, this is a wonderful one. Thank you so much for bringing it forward.
May I?
You're
Thank
welcome. Yeah. And it looks like Representative Babbage has a question for you. Go ahead, Representative.
Thank you very much, Madam Chair. I am delighted to see Senator Hickman this morning, and I think it very appropriate. My first term in the legislature was the 122nd, and my first major speech on the floor was that 2005 bill that made such a difference in the lives so many Mainers. And here I am in my 4th term this time around, and it's only appropriate that you propose this bill to be the other bookend, Senator. So thank you so much for your long service and for bringing this forward.
Thank you, Representative. I appreciate that very much.
Go ahead, Representative Harnett.
Thank you, Madam Chair. I just wanted to welcome my state senator to the Judiciary Committee today, and thank you for introducing this important piece of legislation, sir.
Thank you, Representative. It's an honor to be your state senator. I will also say that the Judiciary Committee is the one committee I have always wanted to serve on, but have not yet had the opportunity. So anytime I get to be in front of you, I'm really happy.
Thank you, Senator. Committee members, anything else for Senator Hickman? Not seeing any. Thank you. And we invite bill sponsors to stay on the panel during the public hearing, so please feel free to stay if you'd like.
Thank you. I appreciate that as well.
Thanks. And at this point, we're going to bring over the ED for the Maine Human Rights Commission, Amy Sneerson. And for purposes of answering any questions that the ED is not able to handle, we're going to bring over Barbara Archer-Hirsch, who is counsel to the commission. So they will both be joining the panel momentarily. And I would ask the committee's leeway to give the executive director of the Human Rights Commission, which is a nonpartisan commission within state government, to give her a little bit more than the 3 minutes that we typically allot to folks who testify before the committee. And so I won't be running the clock for you, Amy Sneerson, with the permission of the committee.
I appreciate that very much. Thank you. Thank you so much, Senator Carney and Representative Harnett, and to Senator Hickman for what I can honestly say is the best introduction to a bill of ours that I can recall. I know you all, I'm going to totally say I Zoom before you now in introduction to all of my testimony, because that's just great. So thank you. I will try not to abuse the privilege you have given me of having a little extra time. My name is Amy Sneerson. I'm the Executive Director of the Maine Human Rights Commission, which is the quasi-independent state agency that enforces Maine's anti-discrimination law. And with me to make sure that I don't give you wrong information or that she corrects it is Barbara Archer-Hirsch, our Commission Counsel. So I'm going to spare you the introductory comments about the American system of law and how it generally anti-discrimination laws like the Maine Human Rights Act stand for the proposition that we as human beings should be allowed to participate in employment and housing in places that are public and education based on our merits and not on where we come from or the color of our skin or who we love. I think it's important to reflect that the Maine Human Rights Act was enacted 50 years ago. Our agency is 50 years old, and for 50 years, we have been coming to the Maine legislature to advocate on behalf of the rights of Mainers to be treated as individuals. And because it's been 50 years, and because you all know of the vagaries of the legislative process, when statutes are amended, sometimes it can be a little messy. And sometimes the agency has a responsibility to come before the legislature and just try to make things consistent and clear to all who might want to know what the protections are and what's expected. So that's the purpose of the bill that's before you. A few key points about it. I did submit written, Barbara and I both submitted written testimony to walk through the portions of the statute. And just a background, this is a bill that was essentially introduced 2 years ago, along with 2 companion omnibus bills. This is the third bill, the 2 others passed. And so there were amendments made to the statute in 2019. This bill ended up dying on the governor's desk just at the pandemic. And so we're here reintroducing it. It's in substantially the same shape as it was when it died the third time on the governor's desk. And there's only a few changes to that. And obviously, a lot of the folks on this committee were in the judiciary at that time. A lot of you were not. So I'm just going to walk through a couple of the key points, and I'm happy to answer any questions. The key purposes behind this bill really is to make consistent and clear across the various areas of jurisdiction, employment, housing, public accommodations, education, extension of credit, what the protected classes are and what they mean. So the first key point is about who can bring a claim, who is an aggrieved party. And in 2019, there was a statutory amendment to clarify and to confirm a long-standing interpretation of the Maine Human Rights Commission that a person can be subjected to discrimination even if they're not in a particular protected class, if they are perceived to be in that protected class, or they're with someone or associated with someone who is in that protected class. And in my written testimony, I gave a couple of examples of that. So a couple of the sections in this bill bring that confirmation to other parts of the Maine Human Rights Act that weren't amended in 2019. It just makes it consistent throughout the bill. A key issue that, again, started in 2019 amendments, but we are carrying through is about, as Senator Hickman, sorry, Senator, talked about, is the issue of the protected class sexual orientation that, as Representative Babbage noted, was added in 2005. At the time it was amended, the statute clumped together a bunch of different characteristics that are kind of related but are kind of discrete. Sexual orientation, gender identity, gender expression, all those things are already protected in the statute and have been for 15 years. All we want to do is finish the process of clarifying to the reader, to the public, the process we started in 2019 of having the statute say sexual orientation and or gender identity, so that it's clear to everyone who is protected, who's already protected. Because some people don't even know that they are protected. So that's I think I noted in the written testimony, I think all the places in the statute where those updates would need to be made. Third, with respect to familial status, as Senator Hickman noted, two key aspects to familial status protection. The first is making them a little more consistent across areas of jurisdiction. This is a protected class currently in housing only, and it only pertains to someone who has or is going to have minor children. We think that two amendments would carry out the purposes of the Maine Human Rights Act. One amendment would be to extend that protection into employment, because as you all know, we all have families. Some of us have minor children, some of us have adults. This is intended to not anyone who may be associated with a person that you have to care for, but a dependent adult. So essentially someone who's not able to care for themselves. So that we would amend the definition both as to who is included in familial status, who counts to give you familial status, and in what areas of jurisdiction. Another change is that, and this is something that was not in the 2019 version of the bill, and this is referenced on page page 3 of my written testimony with regard to section 6. This is about a portion of the Maine Human Rights Act that at our behest, the legislature removed from the Maine Human Rights Act. We were addressing the issue of whether a reasonable accommodation could be whether leave from employment could be a reasonable accommodation for a person with a disability. And there had been a court case from the Supreme Judicial Court saying essentially in a case involving indefinite leave that leave cannot be a reasonable accommodation in employment, and pointing to the particular part of the statute, a particular defense, a burden shifting defense in the employment section of the statute. In order to clarify that a finite leave can be a reasonable accommodation for a person with a disability to allow them to return to employment, we asked you to remove that section from the Maine Human Rights Act. And since that time, we have been advised by practitioners that the removal of that section has cast doubt on whether an employer, about how a defense for an employer applies at this point. Is it still a viable defense for an employer, and how does the burden of proof operate? So we're hoping to clarify that the defense for the employer of whether having a particular employee with a disability poses a direct threat to the employee or others in the workplace, that defense is still available to the employer, and that the removal of that section doesn't delete that defense and how the burden shifting to use it applies. One of the only other substantive proposals that's made in this bill is with regard to public places of public accommodation, in that age is not a protected category. It's not a protected class, which when I speak with groups of older people, which in Maine, there are a lot since we are the oldest state in the nation, over 20% of our population is over the age of 65. They ask me why age is not a protected class. Why is it that they can be excluded from public spaces and services just based on their age? And I have a really hard time coming up with a reason. So we couldn't think of one. And of course, there are going to be circumstances when, say, a minor shouldn't be allowed in a bar. And of course, there may be very fact-specific situations where it is appropriate, but for the most part, we can't think of a valid public policy behind excluding people based on age. Our education portion of the statute is just woefully out of date and inconsistent. So we're asking that it be made more consistent, like race is covered, but color is not. National origin is covered, but ancestry is not. So it's really just bringing that up to date. And the other issue that was not present in the 2019 version of the bill is with regard to administrative dismissal, which is a procedural type of resolution that the agency has utilized to resolve certain cases for a very, very long time, but it wasn't in the statute. And there was some question in courts about whether a case that had been administratively dismissed without a finding on the merits, whether that entitled a person who brought the complaint to proceed to court with their remedies intact. And because in the past year, we have been told by practitioners that this is an issue coming up in courts, that one of the grounds for administrative dismissal, the statute allows for the executive director to administratively dismiss cases for a number of jurisdictional reasons. One of the reasons is that a complaint was not brought in the allowed time. And apparently some folks are continuing, whose cases were not brought timely and whose cases were dismissed for that reason, are seizing upon the wording that we have included in the new administrative dismissal part of the statute to proceed to court and say that it doesn't matter if their cases were brought untimely, that they should be allowed to proceed with remedies intact anyway, which was not the intent. So we're hoping to clarify that, that piece. And those are the big notable things, but I know there's a lot in here and that you're getting this late in the session and that you may very well have questions and that I've just thrown a lot of information at you. So I apologize for all of the above, and I appreciate your willingness to listen to me drone on. And I am happy to answer any questions and to offer Barbara Archer-Hirsch to answer the questions that I cannot. And thank you to Senator Hickman for bringing this bill forward. I zoom before you with grace.
Thank you so much, Executive Director. I'm going to start with just a super quick and I think simple question. You were just talking about the administrative dismissals, and the only paragraph not included is paragraph capital C. So is that the timeliness dismissal?
Correct.
Okay, thank you. All right, I see that Representative Evangelos has a question. Go ahead, Representative.
Hi, Amy.
Hi.
How are you today?
I'm good. How are you?
Good, thanks. Of all the things you went over, quite frankly, I don't think any of them are questionable. All well stated. and totally justified. So I hope we can move ahead with this year. The only question I had was, and it relates to Senator Carney's, in reference to the timeliness. What was the threshold in which they said, okay, it's too late, it was this many years? What was the threshold?
So the statute provides and has for many years that a person has to bring their complaint within 300 days of when alleged discrimination took place. And they can go to court within either 300 days or 2 years. Within 2 years of when their complaint is, nope, I'm not saying it right. 90 days of when we dismiss their complaint. But if they still didn't bring it here within 300 days, their complaint is untimely. So they could still go to court. They just can't proceed with and try to recover attorney's fees.
So they have less than a year?
Yes.
Oh. And are you removing the time limits altogether, or how are you handling that?
No, we don't believe that we have any authority to remove time limits. What we're doing is actually the opposite, is saying if someone didn't file their complaint here within 300 days, they can still go to court on their claims, but they cannot try to get attorney's fees unless there's still sort of a quirk in the statute. If the court finds that we dismissed their complaint, that we were wrong in finding it untimely, then they can get attorney's fees if they prevail.
Do you think this subject needs reform, or are you okay with the 300 days?
I actually, to be honest with you, I have not even thought about it, about whether it's an appropriate amount of time or too long or too short. I don't know.
Yeah, it's an odd number. I mean, normally it would say 1 year or something. Anyways,
We'll note, just for clarification, that the 300 days is the amount of time that the federal EEOC allows. So we're consistent with the federal law.
Are you worried about preemption in that case, that if you did it different in the state, someone could claim that, no, the federal law supersedes the state law? Or is that a problem, or the state can do what it likes?
I don't think it's a problem. They might lose their federal claims if our time limit was longer and they waited somewhere past 300 days, but whatever our time limit was. But I don't think that the federal law could keep you all from giving longer for state claims.
Okay, I'll wrap it up quick. For the work session, just give that a little thought and see if both of you think it should be tweaked or not. I'd like a recommendation of whether it should stay the same. Thanks.
We will. Thank you.
Thank you, Representative Evangelos. Committee members, are there additional questions? Go ahead, Representative Babbage.
Thanks so much, Madam Chair. Ms. Nearson, can you help me? You usually don't recover attorney's fees unless you win anyway. Is that correct? Would you clarify the attorney fees part of what you just said? Thank you.
Yes, I will definitely clarify. You're absolutely right. A person can only recover attorney's fees if they prevail in the underlying claim. Apparently I'm not moving enough. The Maine Human Rights Act provides that so long as a person has satisfied their statutory obligation to come here first, they can try to get their attorney's fees, except essentially if they didn't bring their case here in time. So what this goes to is whether a person who didn't file their complaint here on time can even try to get prevailing party attorney's fees.
Okay, thank you. That does help. Thank you very much, Madam Chair.
You're welcome, Representative. Committee members, are there any additional questions? I am not seeing any. Thank you both very much for the thorough presentation of the bill and for being here this morning. We'll send you back to the attendee space and bring over some of the other folks who wish to testify. Thank you.
Thank you all so much. We'll see you at the work session.
And now I'm turning to those who are in the attendee space and asking any attendee who is here to testify in support of LD 1688, please raise your electronic hand and keep it raised until after I've brought you over to the panel to testify. Okay, there's a number of people here to testify, and we'll start with Alicia Melnick, who will join us momentarily. Welcome, Alicia Melnick, to the Judiciary Committee, and you may begin your testimony whenever you're ready.
Thank you so much. Senator Carney, Representative Harnett, and members of the Judiciary Committee, my name is Alicia Melnick. I use she, her pronouns, and I'm an attorney at Bernstein Scher. I'm here testifying today on behalf of my client, Equality Maine, and our partners at GLAAD and Maine Transnet. Equality Maine, GLAAD, and Maine Transnet are in favor of LD 1688, an act to improve consistency within the Maine Human Rights Act, because it will bring needed clarity and consistency to our vitally important non-discrimination laws. I want to thank Senator Hickman for his powerful introduction this morning and for his leadership on issues of equity and equality. Some of you actually saw this bill last session, as you've heard, but for those who didn't, again, we'll provide some background. In the 129th legislature, there were 3 bills filed to make critical and clarifying updates to the Maine Human Rights Act, LD 1701, 1702, and 1703. Both 1701 and 1702 were passed and signed into law, but 1703 did not make it across the finish line before the COVID-induced adjournment last March. As you heard, prior to the 129th, gender identity was included in the act only within the definition of sexual orientation. This didn't make sense because sexual orientation and gender identity are very different, and each merit their own separate definition. LD 1701 resolved this by establishing a definition for gender identity that is distinct from the definition of sexual orientation. As you also heard, the bill before you, LD 1688, is the 130th legislature's version of 1703. Like its predecessor, this bill makes the necessary changes that correlate with separating the definitions of sexual orientation and gender identity. By adding or gender identity to every place in the Maine Human Rights Act where the phrase sexual orientation currently is in place. We thank the folks at the Human Rights Commission for recognizing the need for this clarification and bringing it before you. In addition, these changes should not only be made within the Maine Human Rights Act itself. We believe Maine's law should be clear and consistent in all places where sexual orientation or gender identity are mentioned, not just those found within the Human Rights Act. To that end, the Judiciary Committee of the 129th adopted a committee amendment to create consistency by making this change throughout all of our statutes. We request that you adopt a similar committee amendment again this year and are confident that your extremely capable analyst can identify all of those places for you. Thank you. I'd be happy to take any questions, but I know you had a very thorough presentation from Ms. Sneerson and the folks at the Maine Human Rights Commission. So thank you for your time this morning.
Thank you very much, Ms. Melnick. And committee members, are there questions? I am not seeing any, but I actually do have a question. Was there a specific amendment proposed in the 129th related to addressing gender identity in other sections of the statute? In other words, is there a document that we could use as a reference?
I believe there is, but I'll certainly follow up with the folks at Equality Maine and with Peggy and make sure we get anything to you so that you don't have to recreate the wheel.
Okay, Tom, Co-Chair Harnett and I can check in with Peggy. Thank you. Oops. Committee members, any other questions? All right, thank you so much.
Thank you.
Next, we'll hear from Megan Sway, who joined the panel.
Good morning, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. Good morning. My name is Megan Sway, and I'm Policy Director at the ACLU of Maine. Thank you for allowing me to speak this morning. LD 1688 makes a number of additions and clarifications to the Maine Human Rights Act, and we're supportive of the legislation overall. I'm mostly here this morning to speak specifically about the explicit inclusion of gender identity as being protected in addition to sexual orientation. As you all know, sexual orientation and gender identity are 2 very separate things. And although the Maine Human Rights Act included in definitions of sexual orientation, gender identity, As time has progressed and our understanding of gender and sexuality has evolved, we feel it's appropriate to separate these out so that ordinary Mainers who are reading the statute and trying to figure out what their rights are can understand that gender identity is covered under the Maine Human Rights Act, and that they don't have to cross-reference, because a lot of people who aren't legislators or lawyers don't know that that is something you would do to be able to find that out. So thank you to Senator Hickman and the Maine Human Rights Act, and we urge you to support this legislation. Thank you.
Thank you very much. Committee members, any questions for Megan Sway or the ACLU?
Thank you. Have a great day.
Have a nice day. Next, we'll hear from Dusty Holman Sprague. Oops. And actually, I inadvertently brought over Jeffrey Young instead of Dusty Holman Sprague. So, Mr. Young, you could go ahead and provide your testimony if you would like to activate audio and video. Thanks.
Thank you, and apologies to Dusty Sprague, who's very articulate on this issue. But good morning, Senator Carney, Representative Arnett, distinguished members of the committee. In particular, I want to thank Senator Hickman for bringing forward this bill. My name is Jeffrey Neal Young. I'm an attorney with Solidarity Law and Executive Vice President of the Maine Employment Lawyers Association, which consists of about 75 lawyers here in Maine who represent employees in employment disputes. NELA supports the enactment of LD 1688. We're the attorneys who have to deal with the inconsistencies in the law on a regular basis, and it'll certainly make our jobs easier to have consistency in the law against because we handle not just employment cases, but public accommodation in particular, occasionally housing and credit cases. So we applaud the effort to promote consistency. I did want to respond briefly to the questions that Representative Evangelos raised. Other states, including California, for example, have a 1-year statute of limitations to bring claims of discrimination. And I don't know whether there's a bill in front of the legislature this session, but a number of states have enacted legislation recently to extend the time periods to as long as 2 to 3 years to bring forward claims of sexual harassment, which is a real problem because often individuals who are victims of sexual harassment are reluctant to come forward. So I think that would be a worthwhile thing for the committee to study. Whether it's appropriate to attach it to this bill, I'll leave to the committee. Thank you, and I'd be happy to answer any questions.
Thank you very much. Committee members, are there any questions for Jeff Young? Not seeing any. Thank you for providing your testimony and for joining us today.
Thank you.
Next, we'll hear from Dusty Holman Sprague, and welcome to the committee, and you can proceed when you're ready.
Good morning, Senator Carney, Representative Arnett, and members of the committee. Your timing could not be better. I have a 10 o'clock meeting, so I will make this short. I join you today on behalf of the Maine Women's Lobby, which advocates for policy increasing the health, wellness, safety, and economic security of Maine women and girls. We are delighted to support this bill and really want to thank the Human Rights Commission and Senator Hickman for sponsoring it. We were founded based on the idea of equity, and so the Maine Human Rights Act is just so closely aligned with our mission and the work that we care about. I'm very happy to see the inclusion of gender identity, but I know that Ms. Melnick and Ms. Sway and others have focused on that. So I'll focus my remarks on the inclusion of the family status piece. At the heart of the family status definition is the fact that families are about care and the responsibility and opportunity to provide this most human of needs. There are 43 million caregivers, family caregivers in the United States. half of them have full-time employment, and most of them are women. When caregivers leave their jobs, it is usually because they lack the flexibility or supports in order to provide that care while working. And this is especially true for low-wage earners and for women, for Black, Brown, and Indigenous women, who are more often employed in the service sector and hospitality industries, or where there's less flexibility and fewer protections. I recognize that these circumstances themselves are not discriminatory, but they're examples of the fact that caregiving in our society is stigmatized, whether that's caregiving of children or adult children in need of care, which this bill specifically addresses. And that stigma creates barriers to housing and employment. It can result in lack of opportunity, a lifetime loss of earnings, contributes to the retirement gap, and of course, outright discrimination. We know of a number of studies that confirm this. At least one found that mothers in particular are 79% less likely to be recommended for hire, less likely to be promoted, and are often paid at rates less than non-mothers. So I will skip ahead here but really just want to confirm that that making sure we address the needs and supports of caregivers in our community is so important to making sure that everyone can provide the supports that they need, that we all need to do as human beings. So we hope you will stand with us in supporting this bill. Thank you.
Thank you so much. Committee members, any questions for Dusty Holman Sprague? Not seeing any, we'll let you get on to your 10 o'clock meeting. Thank you. Just checking the attendee portion of the meeting for another moment. If there's anybody here who wishes to speak in favor of 1688, please raise your electronic hand. Not seeing anyone in opposition, please raise your electronic hand. And anyone neither for nor against, please raise your electronic hand. And I am not seeing any electronic hands. So with that, we'll close the public hearing on LD 1688 and thank the sponsor, Senator Hickman, so much for presenting the bill today. And with that, we will move on to our next public hearing. And that is LD 1692, an act to improve judicial branch facilities in Hancock County. The sponsor is Senator Lucchini, and he is going to join us in just a moment. Senator Lucchini, welcome to the Judiciary Committee. It's nice to see you this morning.
Well, good morning. Normally we'd be next door neighbors with BLA and Judiciary, but it's a little different here. So good morning, Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. My name is Louis Lucchini, and I represent most of Hancock County in the Senate. I'm here to present LD 1692, an act to improve judicial branch facilities in Hancock County. So this bill pertains to the judicial branch's judicial branch's ongoing process of renovating or rebuilding aging courthouses across the state of Maine. The next location that's been identified by the judicial branch for construction is the Hancock County Courthouse. And so I've worked with the state court administrator, Ted Glessner, who's here today on this legislation. And our courthouse, like many old courthouses, has issues with security, technology, efficiency, things of that nature. So we're looking to hopefully rebuild. So several years ago, the legislature authorized a facilities bond to update courthouses in Oxford, Waldo, and York counties. Because of several favorable economic factors, there's sufficient money from that bond to not only cover those projects, but to also begin the process in Hancock County. So LD 1692 authorizes the judicial branch to use those funds to acquire and improve property related to the Hancock County Courthouse. So this won't require any new funding. It simply just requires the legislative authority to spend the leftover funds from the previous facilities bond. Starting the process now of land acquisition would give the judicial branch time to negotiate for property or to search for property, and then return to the legislature next session with a bond proposal, another facilities bond proposal for construction costs. So the judicial branch did a study in 2019 on the location where they would like to build in Hancock County. This was released in March 2020, and then obviously the pandemic hit, so that's kind of slowed everything down. But now that we're returning to normalcy, I think the judicial branch is looking to continue on with their renovation and rebuilding process to build more efficient and safer courthouses. So that's kind of the landscape where we are. As I said, State Court Administrator Ted Glessner is here today. He's obviously very, very involved in all courthouse construction decisions, and he's developed this legislation along with us. He's also presented this information to the Hancock County Commissioners, who voted unanimously to support moving ahead with a new Hancock County Courthouse. So thank you all for considering this proposal, and I'm happy to answer any questions.
Thank you very much, Senator Lucchini. And we have a question from Representative Evangelos. Go ahead, Representative.
Hi, Senator Lucchini.
The representative.
Louis, I attended a couple of post-conviction hearings at the Hancock County Courthouse recently, and I thought I was walking into the 19th century. I'm supporting your request. It's badly needed. There was no security. One of the 2 days I went in, anybody could have walked in with a weapon. Nobody manning the, the detectors and stuff. I actually called Mr. Glessner and alerted him because it was a controversial case, and they got the security in the next day. But anyways, yeah, it's justified. Thank you for bringing it forward. Sorry, I didn't ask a question.
Yeah, no, thanks, Representative. Yeah, like you said, security is an issue. There's multiple points of entry for the public, and the offices are kind of spread out along public hallways. So there's several kind of security issues that we're dealing with there.
Thank you very much, Representative Evangelos, and Senator Lucchini. Thanks for your elaboration on that issue as well. Committee members, any additional questions for Senator Lucchini? I'm not seeing any. We do invite bill sponsors to stay on the panel during the public hearing, so you're welcome to stay if you'd like.
Great, thank you.
Thank you. And next, we'll hear from Ted Glessner. Ted Glessner, welcome to the Judiciary Committee this morning.
Thank you very much, Senator Carney. It's great to be back. You and Representative Harnett and the members of the Judiciary Committee, I greatly appreciate this opportunity to speak to you. Senator Lucchini has done an incredibly great job of outlining the issue, and in my limited amount of time, I'll try not to just reiterate, but to expand a little bit on some of those comments. So basically, the situation is that we have a long-term plan within the judicial branch, and we've been doing this for over 15 years, one by one, dealing with the facilities that are most in need of either renovation or expansion or entire replacement. As Representative Evangelos said, echoing what Senator Lucchini said, Hancock County Courthouse is in really bad shape and is the next one that's up on our list. We would plan to come back next year with a specific proposal. We've already had a study done, which I think does a good job of documenting the deficits as far as that building is concerned and what needs to be done in terms of replacement. And we would come back, as we do to request authorization for funding in order to be able to construct a new building. But that's not why we're here today. This is a more modest request today. What we want to do as a first step in the process is identify where the building is going to be located. That location is extremely important, and we have an opportunity here, really, with not requesting any additional funds to be able to acquire property. The reason is, as Senator Lucchini explained, 6 years ago, the legislature authorized the issuance of bonds for those three major projects, okay? And the ones, we have completed a new courthouse in Belfast. In South Paris, that courthouse has been renovated and expanded. So in both of those cases, we now have two courthouses that have been merged into one. In York County, we have a major project that's underway. It'll be completed within 2 years. And so we'll be looking at going forward, where might we go next? And as I said, where we want to go next is in Hancock County. When bonds are issued, there's bonds are issued through the Maine Governmental Facilities Authority. And because I think we've done a good job of managing our money, because we've had favorable rates, and because delays have resulted in some interest being developed in that bond issuance fund, there is money there that could be used for this purpose. But the authorization in the statute says now that can only be used for those three projects that I identified, as well as for planning for future projects. That's the way the funding is constructed. What we're coming to you to request is that authorization be expanded for the sole purpose of being able to acquire property and develop that property initially for where the new courthouse would be constructed. So not looking for money, looking for authorization to utilize the money that is already there. This does not come at the expense of those other three projects. This is money that we have that is available and can only be limited for these purposes. We have checked with the bond council, just so you understand, when they issue these bonds, they're for a limited purpose. People who buy the bonds know why they're buying them. And bond counsel said this is a legitimate expansion. We've talked to the Maine Governmental Facilities Authority. They're the ones who actually issue the bonds, and they're fine with what we're doing as well. So we feel very comfortable about it. As Senator Lucchini mentioned, we always go back. We're looking locally what the sense is, what the support is. The county commissioners there are very happy about the idea of this project, especially if we can build it as close as possible to the site of the current building. So that's why we're here today. That's the purpose of the bill, and I'm happy to answer any questions that you might have.
Thank you very much. Committee members, are there any questions for Ted Glessner? Go ahead, Representative Babbage.
Thank you very much, Madam Chair. Good morning, Mr. Glessner. Good to see you again.
Good morning.
I actually have three questions. Just the first, could you elaborate again, given the size of the bond and so forth, did things come in more efficiently than expected? Why is there money available to do this within the prior bond?
So there are multiple reasons for that. So much of this, Representative, you develop estimates, far in advance as to what things are going to cost. And when you go out to bid, you don't know what's going to happen. And we actually were more fortunate than we anticipated in terms of favorable results with regard to the bidding. So that, in other words, when you actually start to build the buildings, what is it going to cost? And so those costs came in and they were favorable. We've also had some delays, particularly in York County. That project is beyond the time that we originally estimated. There's actually a positive part to that, because the bonds having already been issued, the money is there and there's interest that's earned on that money. And that can be used for these purposes as well. So I think it's been good management, and I think it's been good fortune, a combination of the two.
Thank you for that. I would ask, one of the concerns in York County, obviously, that we discussed at length last term was the fact that the DA's office is well down Route 111, and it's it's not as efficient to have the geography split as it is. I wondered if the diversion of money from those bonds would have any impact on the possibility, because I really remember the chief speaking about plans for a breezeway to a separate building where the consultations would be made much more easily and so forth. And the fact that federal money, the counties are going to be awash in money here shortly. So I just wondered about the possibility of any of that being impacted by this allocation of money. Yeah.
So there are two issues that have been brought before the Judiciary Committee in recent years with regard to the York County project. One of them had to do with the location, the site. There were people who felt that it should have been another site. Some people wanted the building to be in Alfred and so forth. And you may remember that there was actually a bill that was brought forward to say that the project should be stopped for that purpose. And the committee worked on that, and the legislature considered that, and that was not approved. And so that's the action that was taken by the legislature. And I think what was convincing for the legislature was the fact that the site was selected by a group of 20 people. York County people got together, members of the legislature, one of the county commissioners, the sheriff, the local attorneys, members of the public. There were a number of people who got together. They were the ones who selected the site. And as a result of that, it did end up in Biddeford rather than in Alfred. There were people who wanted it in a variety of places, but that was the way that it was selected.
Yes.
And that's the first part of it. And then the second part, Representative, is that with regard to courthouses, it is the responsibility by statute of the county commissioners to provide for space for the district attorney. And that's specifically stated in the law. So when we have these projects going forward, there's always that conversation with the county commissioners and with others about space in the building. So for instance, in Belfast, the one that we just finished, talked to the county commissioners said that they wanted some space. And the answer to that is in order to meet that responsibility, space was provided, and they pay $10 a square foot for the space that they have in the building. And that's what we do in Augusta. That's what we do in other places. In York County, the commissioners were very clear. They were very candid. I had many conversations. They did not want to spend any money to do that. So the building as designed, the building as is being built, there isn't space for that. There wasn't money put in for that. And what you're talking about with regard to the breezeway, then I'll stop, I promise, is that the question was, could the county build a building on site and then have this connector? And in order for that to happen, you may remember what the county proposed was, if you took the existing courthouses and sold them, would the state give the proceeds to the county so the county could build a building? And again, the legislature made a determination. They did not support that proposal.
Yes, thank you for that. The
Representative Babbage, before you begin your next question, I just ask you to tie it more closely.
Yes,
Bill at hand.
and we're looking for an allocation of money that was appropriated for York County and 2 other locations to go elsewhere. And I'm merely exploring the status of where we are. And the selection of Biddeford as a site, I think is past history, because there was significant legislative representation on the site selection committee, and it was bipartisan. So they chose Biddeford for a number of reasons. And that's not the issue. The issue is the efficiency of the judiciary having the DA, and since the state moved the location away from the county seat, that leaves the county a reasonable, or some would say unreasonable, distance from the new courthouse, and that's a consolidation of 3 courthouses.
Representative Babbage, it sounds to me like you're debating with the
No, I'm
person
not.
who's here to-
What I'm
Excuse me, let me finish my statement, please.
Sure.
And I
Sure.
apologize for interrupting you, but it sounds to me like you are, rather than asking a question, you are engaging in a debate about a topic that is not directly tied to this bill. And I would just ask if you could move on to a question related to this bill. We would really appreciate hearing that question because you'll ask an insightful question, I'm sure.
Yes, thank you. The consolidation of 3 courthouses into one required greater space than the judiciary was actually offering, and that's why they wanted a separate building. So that's why the allocation of money is an issue here. But my third question for you, I mean, I think you've given me the information that you have, but I don't know if there's any clarifying information that you're available to give. But the third question I have for you is the impact of the development of a Washington County DA and separate location for that. Does that impact this at all as far as what you have for plans in Hancock County?
And again, Representative Babbage, I think that the development of a Washington County DA is a bill that this committee has already heard, and I think we've already voted on it. I think we supported it unanimously.
Yes, I'm
somebody can
asking.
correct me if I'm wrong, but I think that's an issue that we've addressed and resolved.
Not contending or contesting that decision. I'm asking its relevance to the allocation of monies for Hancock County.
Go ahead.
So what I would say to you, Representative Babbage, is that I think all of that becomes part of the discussion when the design of the building is being made. I think that in Hancock County, because the county courthouse is there, if we can come up with space that's very close to the current building, it may well be that the county commissioners say, we've got room in the current county courthouse and that will work. We don't know all of that. And that's why all that we're doing now is looking for authorization to be able to purchase the property so we know the site, and that will speak directly to what needs to be built on that site. So it's a good question, but I think you're a year ahead of me. All we want to do at this point is to know where it's going to be built.
All right, thank you for that. Thank you, Madam Chair.
Thank you so much, Representative Babbage. Committee members, are there any additional questions for Ted Glessner? I am not seeing any, and I don't think I had any for you either. Thank you so much for providing testimony and for answering the questions today.
Thank you.
And there is no one else left in the attendee space, so I'm not going to go through the process of asking folks to raise their hands. That will bring our public hearing on 1692 to a close. Thank you so much, Senator Lucchini, for sponsoring this legislation. And committee members, I think that's all we have for today. Representative Babbage, your hand is up. Did you wish to speak? No? All right. Is there a motion to adjourn? Looks like we have a motion to adjourn in a second. Everyone go ahead, Representative Evangelos.
That's a high five motion to adjourn.
High five back at you. Have a lovely weekend, everybody. And Soupy and Peggy, thank you very much for all of your support in this incredibly busy and productive week. Did you have anything you wanted to speak to the committee about before we adjourn?
I just want to say thank you for nice, concise hearings this morning.
I tried to lengthen it as much as possible, but you know.
I appreciate that. Thank you.
Thanks for keeping us all together a little longer today, Chris. Bye, everybody. Have a nice weekend.
Thank you.
Bye-bye.